Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Opportunity. Chairman, I am in agreement with the views you've expressed for and on behalf of this committee. Indeed, as a country, we need to veer off from trivialities and situations where we subject people's reputation to undue public ridicule. I am happy that this committee has boldly stood up for democracy, rule of law, and in helping deal with matters as frivolous as what came before us. Unfortunately, if you look at the ongoing trial of the Chief Justice of the Republic, we have one Daniel Ofori who refers to a judgment which the Chief Justice was involved as a basis for attacking the woman and calling for her removal. If you also read Yakubu Akogo Ayamga, similar frivolous allegations are made that the Chief Justice made certain pronouncement against him in open court. Unfortunately, these two scenarios have been deemed to constitute a prima facie case amounting to misconduct, justifying inquiry into the conduct of a Chief Justice. And the Chief Justice of the Republic is on suspension as a result of this. I am happy that as a committee, we stood firm to the test and we have risen above pettiness and trivialities. Chairman, my second comment has to do with feedback from certain quarters regarding the minorities' stance on some of the issues that have come up as part of this vetting. I would want to pray the public to appreciate where we're coming from. We are not here to get personal. We are here to deal with the law and issues of public policy, good governance. So for those who are saying that, oh, you guys are lawyers, why are you subjecting nominees to all these hard questions when you appear before them? They are also likely to do that to you. Well, my answer to them as a person, I speak for myself. If Mr. Speaker grants me that exemption to practice, I will do as I've always done. If a judge believes that he should rule against me because I did my work, so be it. I've never been afraid to practice at the Supreme Court. When I was in opposition, 2013 to 2016, I was a regular visitor in that court. And I was never deterred by any action or any ruling against me. I will do my job, and I will do so out of great deference, out of great respect. And I'm not here to attack anybody's person. So I want those who are being impatient and intolerant to please understand the space I am in. That is the work of the minority. Our job is to enrich democracy, and that's exactly what we are doing. Don't get irritated. Please bear with us. Thank you very much.
Thank you very much, Vice. We now proceed to give the floor to Togbi Osahin. Alexander Kwamina Afenyo Maki.
Lord, may we go to your CV. My Lord, you indicate in your CV that you speak, that's biodata point 2 of page 1. The last on that, languages written and spoken. 1, English. 2, Wasa. 3, Fante. 4, Tree. 5, Sehui. 6, Nzema. So you write Nzema and you speak Nzema, correct?
Mr. Chair, my writing will be a bit of a challenge after some time now, but the speaking, yes, I understand in speaking.
So you would agree with me that that requires some amendment. Would you,
Yes.
with the leave of the chair, look at what you've stated there? You know, it's mixed up. So if leave is granted you, share with us which of them you write and which of them you speak.
Thank you, Mr. Chair. I mean, with your leave, I can amend it.
Please proceed with the leave of the chair.
I think I write and speak English. I write and speak Fanti. These are three. I think my writing has also become a bit deficient. So I will say English and Fanti I'm able to write. Wasa more or less is also like Tree or Fanti, depending on the symbols you are using. Yes.
My Lord, if we can go straight, sometimes I get worried when the impression is given that when it gets to me, there's a long delay for nominees. Please pay attention so that we can make progress. I'll plead with you. All right. So tell us which of them you speak, and write.
I speak and write English and Fanti. I speak English, Wasa, Tree, Seshi, and Nzema.
So, just for clarity, you can only write and speak Fanti and English, correct?
Yes,
Very well. Just for emphasis, you said you were your national service. You did it at two places. Go to page 4 of your CV. PDC Aboso office. So share with us. You know, the PDC was one of the organs of the revolution. It reminds Ghanaians of a certain past. Here we were, a young officer working in that office. A young officer who has now become a human rights advocate. Share with us what you experienced in that office.
Thank you, Mr. Chair. As I indicated to the earlier question, myself and another individual and a graduate, another man who was a graduate from the university, we were sent there as national service persons. And what I used to do, within that, they have what they call an ABICOM, arbitration committee. And so people with some issues may come and make complaints there, and we were asked to write their statements.
So what was the system of adjudication?
Well, it included things like tenancy issues, and at the time, I must admit, to my surprise, when I became a lawyer, it even involved land matters. And the man who had, I think, a degree in land economy, he and one other senior persons were the adjudicators who would try and resolve these matters. And occasionally, they will visit the lands and find out what land boundaries and so on and so forth. So the matters involve little things. Somebody is owing me, somebody has bought my tomatoes, they didn't pay. So people were bringing some of these matters there. Thank you.
Did you consider this as taking away the work of the judiciary? Of course, the revolution only took away the powers of the executive as constitutionally mandated and that of the legislature. But the judiciary was supposed to be left intact. Did you come to a certain conclusion that the PDCs were taking away the very work of the judiciary from what you've just shared with us?
Mr. Chair, at the time, I'm not sure I was that educated to understand that they were taking away the work of the judiciary, because apart from Takwa, which had a district court and a circuit court at the time, the whole area, there was no court. So from Abosu to Wasankran to Atrebuanda to Insusaiden, there were no courts. So these were ways people were resolving their matters. I rather thought they were helping people to resolve their matters rather than taking it from the judiciary. Thank you.
Lord, with respect, may we go to the Constitution, Article 128. The Lord may read Article 128.4.
Thank you, Mr. Chair. Article 128.1 or 4. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of no less than 15 years standing as a lawyer.
My Lord, with respect, from what you have just read, how many essential qualities are required for such nomination?
High moral character, proven integrity, and at least 15 years standing as a lawyer.
Lord, with respect, on each of them, demonstrate that proof to me.
Thank you, Mr. Chair. On question of moral character, I think that I have demonstrated that through my life. I practiced law in Ontario for years before my elevation to the Supreme Court, to the High Court. A check was done there was no ever complaint at the Law Society against me. I've proven my integrity on the bench by doing my work. As I said, I have desired to always be unashamedly ethical. And come October, I'll be 29 years as a lawyer. So that is what I would say on this one. Thank you.
Chairman, your indulgence, I wish to raise a matter that strikes at the heart of our constitutional commitment to justice and fairness, the presumption of innocence. My Lord Nominee, we have observed an increasing pattern in which state prosecutors, including the Attorney General, convene press conferences or make public statements that cast serious aspersions on the guilt of accused persons, often long before a court of competent jurisdiction has had the opportunity to hear and determine the matter. This trend appears to risk eroding constitutional guarantees under Article 19(2)(c) that every person is presumed innocent until proven guilty. Indeed, the European Union has taken significant steps in this area, particularly through Directive EU 2016/343, which restricts the public dissemination of information regarding criminal proceedings to protect the fairness of trials and the dignity of the accused. Ghana, by contrast, appears to be drifting towards a culture of trial by press and public opinion. And this was long observed by my Lord Apau in the Tagore case. My Lord Nominee, what I'm going to ask you seek to explore your views on how to reconcile prosecutorial communication with the Constitution's promise of due process, judicial fairness, and respect for the rule of law. I will basically, like I've stated supra, rely on the constitutional provision of Article 19(2)(c), and we'll look at principles of fair trial due process, ethical prosecutorial conduct, and comparative standards from the European Union and other democratic systems. Now, how do you interpret the constitutional guarantee of the presumption of innocence under Article 19(2)(c) in the context of public commentary by prosecutorial authorities on cases yet to be sent to court or before the court?
Thank you, Mr. Chair. On matters before the court, I think that as lawyers, each one of us ought to be aware of Rule 38 of the Legal Profession Act, which speaks to the fact that matters which are before the court, if you are counsel, you don't comment on them. So that will be my response, that any lawyer who leaves the courtroom and meets the press outside and begin to talk about what is happening in the courtroom clearly is breaching that rule. On the issue of providing information, I think that this is where there's a thin line. The thin line is that this society has grown a bit sophisticated and we want to receive information. I think I've asked questions this morning about people on social media doing disinformation and misinformation. So that if the Attorney General takes the position that these are matters that I ought to place before the public to be aware of, it may be within the context of providing information. But if the Attorney General goes ahead to make comments alluding that the person is already guilty, in my view, that will be a breach of the Constitution. But providing information to the public who want to know that this is what we are investigating, I think receiving information from the right source is always better than getting it from the social media, which sometimes clearly are manipulated. Thank you.
Chairman, just bear with me, Chairman, bear with me. You see, I would prefer if leader wants to ask his own set of questions, under normal circumstances, I'm the last to ask, then you come in. If he wants to be the last after me, I don't mind. But this issue of follow-up, he should reserve all of his points. When I'm done, he can come in. I will plead with you, Chairman.
Thank you very much. We are Parliament governed by rules. So when a question is asked, the rules allow a follow-up question. So following the same practice within the rules, I'll proceed to give the floor to the majority leader.
You quote the particular rule for our record. Which rule? You quote the rule.
A follow-up.
Chairman, please quote the particular rule.
So I will look for it.
Yes, you look for it. Let's patiently look for the rule, rely on to make a determination, and let it go in the records. Quote the rule that allows somebody else to interject with a so-called follow-up when the person is entitled to his own. It's entitled to his own set of questions. So quote it.
The public, let's look at Standing Order 89. It's on supplementary question. And if I may read the relevant portion, 89.2 or 89.3. Any other member may be allowed to ask not more than 2 supplementary questions, except that the majority and the minority or co-leaders may ask not more than 5 supplementary questions on the substantive issue. It is on this order that I am standing to give the opportunity to the majority leader to ask a supplementary question.
Chairman,
So
with
order
respect.
89
Chairman, with respect. You may continue to exercise your powers, but let me help you. The rule you've just quoted governs plenary proceedings. If you want to apply it mutatis mutandis, you are supposed to still be guided. Because I am asking the question, that rule says, after the person asking the substantive question is done, I must be done with all my follow-ups. Before, then you would ask me, are you done? Before going on, I laid bare each of the steps I want to take. So you should ask me first, am I done with that substantive question? If indeed I say yes, and you want to apply the plenary rule, mutatis mutandis here, you may now give him the chance, but don't say you are guided by the rules, and even when I am not done with my supplementary questions or follow-ups, you want to give him the chance. Let's stop this. The leader is entitled to come in anytime when we are all done. He can ask his own questions, so stop this. It won't help.
Honourable members, it's not everything that I place on record. You realize that before giving the opportunity to the majority leader, I asked the questioner that majority leader will want to ask a supplementary question, not into the microphone. So if you are not done with a supplementary question, you can also tell me that you are not done with a supplementary question on that particular question. That doesn't mean I do not have a floor or do not have the ground within the rules to ask the leader to ask a supplementary question. So if you feel that you have a supplementary question on the question that you have asked, you can ask that particular question, and thereafter, I will give the opportunity to the majority leader to also ask a follow-up question. But rather, you said, which rule am I relying on? I have shown you the rules. So I'm not operating outside the rules.
There are rules that govern committee work. Chairman, anyway, I'm not done, so let me finish my supplementary. Now, let's deal with the issue of ethical guidelines. You have just spoken about the boundaries, that it could be in the public interest for the minister to put out some information. Now, do you think that there is a need to provide some ethical guidelines to govern this prosecutorial communication?
Thank you, Mr. Chair. And If I may seek clarity, ethical guidelines as to guidelines governing how ministers do their work, or with this particular situation?
Very well. So, in my first answer to you, first question to you, you answered in a twofold. First, you said that if the Attorney General is saying anything that would prejudice the outcome of the case, then that would amount to a breach. Then you again said that it could as well be that there's a need to provide information to the public regarding the case in this era of social media and all. So on the basis of what you've told us, I am mounting the follow-up to ask whether on such a thin line you hold the view that there's a need for some legal or ethical boundaries that should govern public statements by the Attorney General or prosecutors about the accused persons before trial commences.
Thank you, Mr. Chair. I think that the Attorney General remains a lawyer. If there is any member of the Attorney General's office who is a lawyer, I would say that they still must advert their mind to LI 2423 as lawyers, and their roles as prosecutors are well set out in the LI. If the person is not a lawyer and will not come under that ambit, then maybe what you are asking may be appropriate. But I think your question clearly, hardly do we see police prosecutors, for example, doing that. So that if it is someone who already comes under LI 2423, then my thinking is that there's already some rules there governing how such work ought to be done. And in regards to public statements, that is covered under Rule 38. Thank you very much.
Now, to what extent do such public declarations of guilt by state prosecutors, even before trial, in your view, can undermine public confidence in judicial independence and the impartiality of criminal proceedings? My Lord, I would give you a bit of a background just to help the situation. My Lord, sometimes, the court is often accused of not ensuring justice, not being fair, all because a certain impression has been given them that somebody is already guilty. Why did the court even grant bail? Why is the court saying that he's acquitted and discharged? Why is the court using rules of procedure to free somebody? So, with this as a background information, would you say that to some extent, some of these public declarations, which in the ordinary man's language, understanding, amount to a guilt, will undermine the public confidence in the judiciary, because it's already been said out there, and you are now sitting in as a court of justice to determine the matter?
Mr. Chair, when it comes to judicial independence, clearly, as we understand it, there's decisional independence and institutional independence. The decisional independence is the judge's ability to hear evidence, the facts, and applying the law. So that I think I would rather be shocked that any judge who understands his role ought to be influenced by a statement made by a prosecutor or the Attorney General even before the matter comes in. I would do my work, or judges do their work, based on the evidence they receive in the courtroom. Yes, for an uneducated mind, it might create the impression that the judge has done something untoward. But we only speak through our judgment. As a judge, when I write a judgment, I must have my spirit in it. So that when I have demonstrated that and you disagree, my position is read the judgment. And your opinion, you may want to disagree with me, but I have spoken. So yes, if providing that information will make people think that the person is already guilty, but the trial did not meet that standard, I think it rather undermines the integrity of the person who put that information out there than the judge. Thank you.
My Lord, I know definitely Apau J, as he then was, and his brother Pesera, the position they took in the very matter that our respected AG did in the Tagore case. It provides a new pathway, which you've emphasized this morning. But essentially, reading that judgment, I got the impression that you, the judges, are often concerned, or perhaps you are put under some pressure when the public perception is already out. Because if you see the way my lords emphasize the point that the fact that a case gains public notoriety does not whittle down the essential ingredient required to prove the guilt, it tells you one thing. It's on this basis that I want to ask you whether unmeasured approach in such public pronouncement by the prosecutor, in your view, undermines the very justice of the matter. In all fairness, you are on oath.
In all fairness, yes, let me say that, especially as a teacher of advocacy and legal ethics, I think I will be concerned when lawyers leave courtroom and make comments on matters pending, and sometimes the fact will not represent what took place there. I'll be concerned about that. But prior to filing the matter, if it is something providing information, I would think that might be appropriate, but there is a certain line. Do not make comments basically throwing somebody under the bus before even a suit is filed. Thank you.
Lord, then human rights, remedies.
Before you go to human rights remedies, I will proceed to give the floor to the majority leader to ask a question.
No, wait, Chairman. On the presumption that you've not, please. Chairman, you know, in my opener, I can share with you, this is the main question, under 19.2c. The remedies comes under, they are all follow-ups. So I only give the subtitle to help the nominee. So when I under the same thing, please, they are all my follow-ups. I have main question, I've drafted them carefully. So let me get done. He would have the opportunity, please. It's my follow-up. I'm the questioner. The rule allows me to ask 5 supplementary. So let me finish. They are not. They are 2. Chairman, they are here. I've listed. I'm going by my own work.
So to go by the rules that I have quoted, you are entitled to 5 supplementary questions. And the questions that you have asked following the substantive questions are more than 5. A question was asked whether or not he is a member entitled to ask a question. We should make reference to Standing Order 2177, which entitles him to participate in the decision. So you have the floor. You can ask a supplementary question.
My Lord, you become aware of, because you talked about patriotism, let me ask, you become aware of the Ghanaian pledge, that pledge, I promise on my honor. Can you recite it?
Mr. Chair, I'm not sure I'm able to recite it.
Which aspect? Not the full, any.
Well,
what you can.
My brother. Yes, the nominee is honest to say that I will not be able to recite it. So why will you insist? I mean, an honest answer has been given, I wouldn't be able to do this, but do it. No.
Lord, I did not say that in spite of you saying you can't recite it in full, you should still recite it. In spite of what is telling us that you can't recite it in full, you should still recite it in full. That was not the mainstay. I only said, share with that those aspects that immediately comes to mind. Did you get what the point? That I only said the aspects that readily comes to mind. You've admitted that not in full. So which aspect readily comes to mind?
I promise on my honor to be faithful
and loyal to
Ghana, my motherland. Thank you.
I promise to hold in high esteem our heritage,
won for us
through the blood and toil of our fathers.
Exactly.
I promise to hold in high esteem
won for us
toil of our fathers.
Yes.
And I promise, pledge myself in all things to be faithful
and loyal to God,
to uphold and defend the good name of Ghana.
Have you seen the way you are also
because I
struggling?
am helping. If you don't, the man, no, stop. Chairman, put off your mind. This is, look at, okay, if I'm struggling, can you do it yourself? If I'm struggling, I have made an attempt. If he said he couldn't, and I said, oh, an aspect. You are now telling me that
that is why I am not making an attempt.
Then allow me, I would want to make an attempt.
Because I don't want to struggle.
Don't worry, I would want to boldly make an attempt. When I make a mistake, I be corrected. I'm not afraid to make a mistake. It's good to make a mistake to be corrected.
But let me say this, honorable member, I think that in as much as a pledge, it's a great thing for all of us to know. I'm not sure Ghanaian patriotism must be anchored in our ability to recite a pledge only. There are other things that all of us can do to demonstrate our patriotism to the country. Thank you.
Lord, with respect, that will be all for you.
Honourable members, our revered guest nominee, at long last, the vetting of the nominee has ended.
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.